So good afternoon. The Multnomah County Circuit Court Diversity, Equity, and Inclusion Committee welcomes you to today's Lunch and Learn on adding adaptive technology in the courtroom. For those of you who don't know me, my name is Multnomah. I use pronouns she, her, hers, and I'm a judge here in Multnomah County. This Lunch and Learn is being recorded. The recorded session will be available to OJD judges and staff next week, and a link to that recording, as well as additional links for resources related to today's topic, will be sent out to judges and court employees in a subsequent email. Please feel free to ask questions at any time throughout the presentation by typing them into the chat box, and we'll make sure that our speaker sees them. Closed captioning is available for anyone who would like to use it. In WebEx, to start your closed captioning, just find the teeny little button in the far lower left corner of the screen that says CC, and that will start your closed captioning. And remember that at times our speaker may pause just to allow the closed captioning to catch up. CLE credit is available for this presentation. So if you're an attorney and would like CLE credit, please type your full name and bar number in the chat, and we'll pass that along to the bar. At the end of today's session, we will post a link in the chat to a feedback survey. Please do take a moment to provide feedback for both the presenter and the DEI committee. I also want to take a brief moment to remind everyone that July is Disability Pride Month. The DEI committee is holding a 4-part discussion series on the ABA's 21-day Disability Equity Habit Building Challenge. And the first discussion is tomorrow, July 7 at 12 o'clock, and that will be in the jury overflow room on the 3rd floor of the Central Courthouse. And the topic for tomorrow's discussion will be disability language and etiquette, facilitated by Judge Odin Orr. The next dates will be July 14th, July 17th, and July 28th. So watch your email for emails from Roger Rand with reminders. We also wanted to make sure everyone knows that our committee has a new internal SharePoint site. Just click on the Diversity, Equity, and Inclusion link on the court's homepage to access past recordings and other DEI resources. It's now my pleasure to introduce our speaker. Malik Summer is a circuit court judge in Washington County. Judge Summer has done workers' compensation defense, served as an administrative law judge, and practiced family law for several years before taking the bench. In 2020, he became a municipal judge for the city of Beaverton. And then Judge Summer was appointed to the Washington County Circuit Court in January 2022. He is actively involved with the Oregon Attorneys with Disabilities Association and holds the distinction of being the first transgender man judge in the country. So Judge Summer, welcome, and please take it away.
Thank you so much. I really appreciate you guys taking the time today. I have a presentation that I kind of give on this issue, but I would encourage all of you to ask any questions. I am so much better at dialogue than I am at just talking at people, which sometimes makes my job a little hard, to be honest, but it is my preference. So please feel free to interrupt and drop something in the chat. And Judge Long will interrupt me if I am too slow to keep up with it and let me know that it's there. So I like to start this by giving people a little bit of background on the Americans with Disabilities Act. I think that context is helpful, and keep it pretty simple for our work because it's a very broad law and it covers a lot of things. It was enacted in 1989. I do think it's kind of funny and fun that it was enacted by George Bush, the first President Bush. The second President Bush substantially modified and, in fact, expanded it or bettered our understanding of how to use it. So I guess it's just a family affair for them to be working with this law. The Congress enacted the law after finding that people with disabilities encounter discrimination, access to public services, have a history of unequal treatment, and have been relegated to political powerlessness based on stereotypes that don't affect our true ability to participate and contribute in society. So, most pertinent to your work is Title II, which prohibits discrimination in public services and prohibits exclusion from those services on the basis of a disability. So there was one Supreme Court case that is very important to this issue, very specifically to our work, Tennessee versus Lane. It was from 2004. The plaintiffs were disabled persons that couldn't access the upper floors to courthouses because of stairs, right? They had mobility limitations. So they argued the state of Tennessee was denying them those public services because of their disabilities and that it violated the ADA. So I have a quote from the Supreme Court related to from this case. The unequal treatment of disabled persons in the administration of judicial services has a long history and has persisted despite several legislative efforts to remedy the problem. It's going to specify that recognizing the failure to accommodate persons with disabilities will, quote, often have the same practical effect as outright exclusion. Now that makes sense, right? I mean, the reason that people, let's imagine you are a criminal defendant, you've been charged with a crime, you have to appear for court and it's on the third floor and you're in a wheelchair and you can't get there and then you're warranted. So it compounds the problem that you already have. And you quite simply, the only reason you couldn't get there is because of stairs. So the Supreme Court recognized that and found for the plaintiffs in that matter. And we move forward here today and we think about what we do and how we can accommodate people and make sure that they access justice, that we access justice the same as anybody else. So the ADA defines disability. It is a physical or mental impairment that substantially limits one or more life activity. That makes a lot of sense. And there's a lot of things that you immediately think of, right? And some of those things are, I just raised one of them. Walking is considered a life activity, moving around. So when you see somebody with a wheelchair, you think, okay, this person has a disability. There are other disability aids that people use, like hearing aids or canes, that clue us in to the fact that they are limited in one or more of their life activities. But what people often don't contemplate, and what can be trickier to both identify as well as accommodate, are things that inhibit thinking or emotional processing. So depression, for instance, is a disability. And, and I'm talking about diagnosable things. Something else to think about, though, to kind of change your perspective on what disability means, is consider that glasses are an aid, the same as a hearing aid, right? But we look at them very differently because so many people use them. We don't view that as a disability culturally, but when you think about it, somebody's life activity, seeing, is substantially limited. They were so limited that they require an aid to be able to effectively function. It is no different than something like hearing aids or a wheelchair, really. Another thing that people often don't contemplate is substance use disorder or alcohol use disorder. Those are diagnosable conditions that qualify as disabilities under the ADA. And accommodations for them, I talk about this more with lawyers and law firms, but, can run the gamut too, as simply making time available to attend AA meetings or things like that. That's a very reasonable accommodation for somebody with that particular condition. It can be hard to out yourself and tell people that you have a disability. It can be hard to use the terms, I have a disability, but those are the sorts of things we ask of people in our system. And some of the stuff I want to talk to you guys about is, how can we bridge that gap? How can we reach out rather than waiting for people to reach our direction? I think that's important. In order to consider that, we have to think about, who does the ADA apply to? In our circumstances, in our world that we're talking about, it applies to literally everyone. It applies to parties, defendants, people appearing for their civil cases, landlord, tenant. It applies to jurors. So when we are setting up our juries, we need to contemplate what kind of accommodations we might make. It applies to witnesses. It applies to lawyers. It applies to observers. So that person that comes in that wants to just observe court. Now, this stuff doesn't happen that much, but maybe can we think that it should happen more? The courts are open. People should be coming in and seeing the work we do and being proud of the work that we do. And we want to make it easy for them. If somebody comes in and needs an ASL interpreter to just be able to observe, that's not an inconvenience. That's us creating access for people that want to know the work that we do as government workers. So I think observers is the thing that people are surprised about and don't think about that much. As a judge, I can tell you, I am always surprised when somebody comes in and just wants to watch me work. It's a little unsettling. I think there are a couple other judges here because you wonder why they're there. But the reality is we should be encouraging it so much more, and we need to make it available to everyone. And that sometimes means inquiring, what they're doing and do they need anything, because sometimes they do. So I like to tell my personal story because I think it gives everyone some context of what it is like to live with a disability and also how they can be impacted through the justice system. I am a disabled person. In 2016, I became very sick, and ultimately I was diagnosed with an autoimmune disorder. I am disabled in a variety of ways because the autoimmune disorder causes some substantial pain and sometimes fatigue. But most readily and sort of most substantially, it impacted me because I lost most of my hearing. So I wear hearing aids and I am using captions right now. It's always funny to see your own words on captions, and have had to navigate it after that happened. When I first got sick, I was hospitalized for several weeks and I had to miss court. I love to tell this story, but I had a business partner at the time, and so she was scrambling. She obviously had a full caseload too, so we're doing filings, asking for resets. And I'm very sick, and nobody could identify even what was wrong with me, so it was very scary. And a judge denied one of my motions to reset. And so my partner managed to finagle her schedule to show up for trial assignment. This was in Multnomah County, actually. And the judge that was doing trial assignment was Judge Allen. And she looked at it and she looked at my business partner. So this is Summer's case, know me very well. Well, where is he? Okay, I'm resetting this case. And was just so kind because, when you work hard and you try and make yourself available, when somebody recognizes that something is wrong, I will say in your court, they come through and recognize that, that perhaps this is something very serious. The reality is I hope that people don't have to press so hard to be taken seriously, and we'll talk about that in a few minutes, a little bit greater detail. But it was a nice thing to know that she looked at the circumstances and thought something is not quite right here and worked hard to kind of make it easier for us in a time that was very hard. So when I got better, I walked with a walker for a while because when your inner ear system is impacted, your balance is substantially impacted. So I used a walker and then I used a cane until I could walk without an aid. I like to tell people it was like having shaky cam in a movie all the time. It wasn't swirly like vertigo, it was shaky, but I had a difficult time walking without assistance, and I was very self-conscious about it. I went to court as a lawyer, and I was using a cane, and I was in so much pain. It was really difficult, but I had to, keep working and try and get back to myself. And a lawyer later told me that she thought I was a drunk because of what she observed of me using a cane. It was really hurtful for me and a scary thing. I also coached youth sports at the time. I still do sometimes, usually sports I don't know how to play. And it was a scary thing to think about people thinking that about me when I was responsible for their children too. Or, I was doing family law, responsible for their lives and their families. I was so self-conscious about it. And then later, I had a trial in Clackamas County, and the lawyer who wanted to interrupt me, he thought an appropriate way to interrupt a person with hearing loss was to physically put his hand in my face. I'm sad to say that the judge did nothing about that. And, it was intimidating and uncomfortable, and reminded me that while our people that work in the justice system in the Portland metro area are largely lovely and supportive, but there are always going to be a couple people that make things harder. And when we work for the courts, it's our job, in my opinion, try and intervene when that happens, because we are responsible for making sure the playing field is level. I don't know what all of your jobs are, but I guarantee you all play a role in creating a level playing field for people that are going through the worst moments in their lives, all of us. So when I think about those moments, I think I have to be able to do better. And I hope I can explain to other people how to do better. So this experience sort of changed my perspective on disability. I am, as Judge Long said, I am trans man. I'm also a person of color, and I have experienced discrimination. So when I added my disability identity, I thought, I got this, no problem. I am an intersectional person. I can do this. I had no idea what it was like to live in a world that was built for other people, not me. The physicality of it is very different. There are times where I go out in public based on my appearance where people are aggressive to me, and I am used to that. I am not used to going someplace and quite simply not being able to function. And I had that difficulty for a long time. So it also made me recognize my bias. Um, I will confess that I assumed I had different expectations of people with disabilities. I did not assume that we are as capable as we are. And I sent the organizers an article. It's actually sort of a report done by the Washington court system. And some of the things I learned from that, besides the fact that we should do it here, I was thinking about it this morning. Why do we have to use Washington? We are cooler than Washington. We should have our own. But one of the things I learned is 80% of disabled people are unemployed, right? That is not necessarily because we're all incapable, but I felt like it at first. And I wondered if other people weren't as well. I will confess my bias. I think it's important to think about your biases so you can work through them, especially for people in my position who are making decisions for other people. If I don't recognize it, then I can't work to remedy it and make a fair decision. So what we all want is to just be treated with dignity and respect, right? We want the same treatment as other people, but what that looks like looks different sometimes. And so I want to talk to you all about technology. And I'm going to draw in at least one of the judges, maybe two, and hear a little bit about what you all have now for the sound system for hearing. Because I'll share with you, I don't know, maybe you all have worked for Multnomah County for a long time, but let me tell you how absolutely terrible the system was a few years ago in your old courthouse. It was so sad because by the way, once you identify as deaf and you join in organizations around it, and you're maybe one of 3 lawyers in Oregon that self-identifies that way, you get all the calls from every deaf person that needs a lawyer in the state. And so I ended up having a lot of clients who were hard of hearing or deaf and had to access that technology. So at the time, most of the time, it didn't work. You know, we'd get in there, we'd get the system, they'd shake it. It's clear that it hadn't been used or tested. And so the first thing I want to remind everyone of, check your systems and make sure they still work. You don't use them every day, and that's great. But it is important that we are aware of what they can do and whether they are in fact working. There's nothing more frustrating to the parties and to the judges and everyone in the room when we have to reset a case, right? Because we quite simply can't get something to work because we don't have an interpreter. That happens sometimes, or our technology doesn't work. So if Judge Holmesand or Judge Long, would you mind sharing with me what your system for sound is like now?
Would not be more significantly better. It's so much better, so amazing. It used to be very common that people would put it on and say, no, no, no. And now they get this look of, I can hear. And it's, I would say that the juvenile courthouse, they've improved, but it's not as amazing because it's not built into the building in the same amazing way as it is downtown. I don't know, Judge Holmstein, if you have.
Yeah, I agree with all that. Also, in our new courthouse, the entire room is mic'd, so people can be heard much better, and which helps, I think, everyone, including people who have challenges with hearing. And the quality of the recordings of our hearings now is greatly improved. You know, I can listen to an FTR and actually hear what everyone is saying, which is just like the sky opens and the rays of light shine down. So it's a huge thing. And having struggled through many a hearing with people with difficulties perceiving what others were saying, what I was saying, and seeing their frustration and their inability to be heard, it's a huge improvement. So thumbs up to the courthouse tech people who helped give us this new world.
I want to piggyback on something you just said that now the FTR is better, right? Which I have also found to be the case in my courthouse, because I tell people speak directly into the microphone, and that is so common. When we make an accommodation for a disability, that we actually make lives easier for other people too, right? I find it, I think that what this has come up with a lot is during COVID, frankly. COVID made us recognize things that people with disabilities, especially things like autoimmune disorders or things that cause chronic fatigue, that we needed to take better care of ourselves. And so all of a sudden, right, we have things like this. We're doing this over, what is it, WebEx. I was about to say Zoom, because Zoom is like Kleenex, you know, we use it as the generic term for everything. I found that so interesting, because these were things that have always mattered to some people, you know, but now matter to more. So we decided to take it more seriously, and we decided to. I think the biggest thing that we came out of this with is the cultural idea that people need a freaking break sometimes. So, you know, we do not necessarily shame people as much as we culturally did before about taking days off from work because they maybe don't feel great. Like the attitude used to be, especially in the legal community, if you can get up out of bed, then you should probably be working, you know, and that is just quite simply not true. And people with disabilities need that extra time. And so Judge Long mentioned the Attorneys with Disabilities Association. Meeting those lawyers made a substantial impact on my life. I was trying to be a judge. I was applying to be a judge, and I was doing it almost half-heartedly because I thought, I can't do this anymore. I'm not capable. And then I met all these amazing, smart people like Judge Brown from your court that were so capable that I thought to myself, this is ridiculous. Like my attitude around this was so silly. If they can do these things, I can do something still. I'm 46, but not above that kind of childlike emotional response to things. I still need a sense of community. I still need to see examples. I need representation. It makes a difference to me. So I saw these people doing amazing things, and we talked for hours about the things that would help us, how some people needed to work from home because they needed to be able to take a nap at 2 o'clock because they hit an exhaustion point in the afternoon and would often work outside of typical business hours, and they needed ready access to a place to rest. That person who told me that is freaking brilliant. And the idea of excluding her from any space because of those needs is a great loss to that space. You know, never mind what it is a loss to her. It is a loss for all of us if we did not have access to her intellect and her ideas. So what can we do in the courthouse? What can you guys do? Again, I don't know all your roles. So if there's specific questions about things you do, let me know. Some of the things that I think about, though, are technology. Our websites, they are not great. I don't think anybody here thinks that OJD websites are awesome. They're usually kind of cluttered. They're kind of messy. They're difficult to find things. There are things called disability widgets that cost very little, that you can add to websites that do things like make sure that the page is screen reader accessible for people with visual restrictions. They change the font for people with learning disabilities to make it more understandable. I find it fascinating to make all the changes so I can just experience them. It's kind of fun. But they just make everything easier. It's just a button. I will tell you that if a business uses one, I'm more likely to patronize the business. It's beneficial because it implies the commitment to diversity that we all want to see. I mean, that's why you are all here. But most importantly, when we're talking about the justice system, it makes sure that a juror gets all the information they need to be able to make it to court. It's an easy thing and something that we should be advocating to change. And I don't know if that's something that has to be done through OJD Central or if it's something that local courts can do, but I would suggest looking into that. Your court likely has an ADA coordinator. Are any of you the ADA coordinator? No? Okay. I think that
She's
does
not here
anybody,
today, but she's on our DEI committee and is amazing.
okay. Do you all know who it is? Yes, I'm seeing nods. This is great news because you know what? At my court, not everybody knows. That's an incredibly helpful thing. But very frequently, especially at smaller courts, you guys might be different. That person is just an administrator that doesn't necessarily have any kind of training or specialized knowledge. We need to advocate for them to be more equipped. They're probably great people, and they may have sought out information on their own, but there are trainings and things that people can do to better understand. The other thing is that when you are disabled, you do something called self-accommodation. You try and make things work because you don't want to be a bother. You figure it out, you pretend to hear, you do all kinds of stuff to make things easier on the rest of the world. I'm telling you that so when you look at somebody and they come to you, you ask. There's nothing offensive about asking, just like asking somebody for their pronouns. I mean, it's not an offensive question. They can tell you that they don't need anything. And the other thing is try and think of ideas to accommodate, because sometimes I am still deeply overwhelmed by what it is I need and I struggle with it. I have a funny friend who feels compelled before we go anyplace to call the place and let them know that I'm hard of hearing and to ask what are they going to do about it. She is very sweetly aggressive on my behalf. But what this led to is us, for instance, when we were out at a museum in Washington, D.C., as having a special person walk us around and talk loud enough for me to hear about all the exhibits. It was great. So you never know what places are willing to offer, is what I discovered from my friend who is braver than me. And, it's always easier to advocate for someone else than for yourself. So think about that. What ideas do you have? You find out what the issue is, and then maybe you have some ideas. And let me remind you that they're not always simple. So they need to be reasonable, but that doesn't necessarily mean they have to be expected. So as a person who is very hard of hearing, I don't have a deaf accent, and people often don't presume my hearing loss is severe as it is. It's very, very severe. I lip read, and I use hearing aids, and I use captions. I do not know ASL. And the immediate assumption when you hear that somebody is hard of hearing or deaf is to presume that they know ASL and to offer that. And that's fine to offer, but you have to recognize there is a large segment of people with my disability that do not know ASL. Usually they're like me and they're what's called late deafened. You lose your hearing when you're older, then, I'm not as smart as my 12-year-old, and learning a new language is real tough. I have tried, I've taken a class, and I've learned a tiny bit, but not a lot. So what else can be done? There's a system called CART, for instance, that does live captioning. Sometimes, the hearing things that are typically used in courthouses, they go over your ears, and I can't wear them because they go over my hearing aids, right? My system allows me to Bluetooth, actually telecoil into our system with my hearing aids. So it goes to all of the microphones in my courtroom. And that was a recent upgrade to my courthouse in all courtrooms. So people with hearing aids can use the system, but don't have to put headphones over their ears because it causes horrible feedback that is very upsetting actually, I can't hear it. It's very upsetting for all of you if you have to listen to it. So, you have to think about this and recognize that not everybody's accommodation is necessarily what you expect, right? Sometimes it is it's something that you're a bit surprised at. People will, in my court, and I suspect there's some similar process for you guys, if they need an accommodation for their case, they fill out an accommodation request. And I have seen judges be dismissive of them. Sometimes people will ask something and it seems silly, or the way they phrase their disability challenges your expectations of what a disability is. The reality is that it might be slightly irritating to a judge to have a friend sit with somebody, but if they have substantial and generalized anxiety disorder, that non-lawyer sitting next to them is critical. It makes a difference to their ability to present their case. So I just want to and maybe they didn't describe that well. Maybe they just said, I'm nervous and my friend needs to sit with me. I mean, that's not a great description of their disability. And it's not a great description of their needs. But what is the harm in letting it happen? There really isn't one. I mean, granted, you occasionally have a circumstance where you get in there. I was a family law judge for a while. I do criminal now. You get in there and then you find out the friend sitting next to them is a person who has the other party has a restraining order against or something like that. And you think, oh, okay, let's figure out a different way. But most of the time, what they're asking for is innocuous, even if it seems a little, quote, weird to us who don't need it. I know that when I was in practice, my partner had an opposing party who requested to lay down during the trial. Weird? Yes. Substantial orthopedic issues, though. It's strange, but really, what is the harm? It's just, I will tell you, the judge then can go home and be like, I had a whole trial today where a person laid down the entire time. And that's kind of a funny story. So, but it doesn't really hurt anyone. I think that it can be done. And so I want to encourage everybody to think about those kinds of stories and think, all right, what is it that we can do that is outside the box? And maybe the next time these things come up, you have a suggestion, because we are scared to ask. And sometimes we don't know. And these are people who are overwhelmed because, again, they're going through the worst thing in their life. They're going through a divorce. Their kids have been taken by DHS. They've been charged with a crime. We blessedly have a few things like adoptions, which are lovely, or some of us do weddings because we need that shot of positivity after doing 30 arraignments. So, but a lot of the time people are experiencing rough stuff and they are not thinking very clearly. Any of you who have public facing jobs, I want to talk about that. Sometimes people are going to challenge your patience. Take the extra time with them. This is low tech here. This is me saying, ask if they don't seem like they're understanding. Ask them, maybe, would you like me to read this to you out loud? I know it takes you some extra time, and I appreciate so much how hard you all are working, especially when you have those kinds of jobs where you're talking to people that are dysregulated and upset every day. And maybe they're not scared of you the way that they're scared of Judge Holmes-Hayne, I think that it can be tough for you guys to take that time with people, but it is so worth it, because what you are seeing, them being upset, them being angry, the low tech solution, I know that we're supposed to be talking about technology, the low tech solution for you all is to stop a moment and maybe go a little slower, even a little slower, and see if you can bring them down, and you don't underestimate your ability to gauge whether somebody is actually understanding what is happening. And if they maybe don't presume necessarily that it's drugs or alcohol. Think about all the possible options. And even if it's drugs or alcohol, again, what is the harm of taking it a little slower? Maybe that it penetrates whatever is impairing them. So those are some low tech solutions. Look at those accessibility requests, and it looks like the form has been dropped in the chat here. And be generous with them and be open-minded about them, because it really, again, what is the harm? Typically, there is not. Everybody has to gauge that because, again, the accessibility issues are reasonable. Um, if somebody has, let's say you have a trial too, you have documents, and the other side is presenting them, the other person is blind. Is that justice that they cannot read it during the trial? It is not. Do we have things that can do that? Yes, we do. We can actually scan documents to a computer that has a screen reader. These are things that you might not have thought about yet, technology that exists that is in fact likely even free to access, but you can prepare yourselves by familiarizing yourselves with these kinds of options. They don't come up a lot, but they come up sometimes. Is there space for wheelchairs? Physical space. Your new courthouse is gorgeous and big and likely has thought about all of these things. But are there still ways that it's hard? Especially for busy, say, trial assignments and things like that. Are there ways to make it easier? Those are things I want to encourage you to look at every time you enter a room. And this again is why things like representation matters. Oh, look at that. Roger says there's only one door into the building. That will go terribly if you have a fire, right? You have a bunch of people, I'm even talking just people who are walking and are totally and completely able-bodied. One door sounds like a terrible idea. But then if you add people, multiple exits, but only one entrance for the public. If you have multiple people that have some mobility limitations, then you add extra challenges there. Judge Holmes' hand has her hand raised.
Yes, I was just, you're mentioning of the doors, which PS, I just want to say, thank you so much for taking time with us today and also for sharing your personal story. It's just very impactful and real. Really helps us kind of think hard about how we do and how we might be able to do better. But, you know, even in our new courthouse, which is splendid in many ways, you sometimes don't realize how something could be a barrier to a person until you're living and working in it. And I had a hearing the other day where a person had a lot of physical challenges and was trying to get out of the courtroom, and the doors were too heavy. And there isn't a handicapped button on our courtroom doors to allow people out easily. And so my clerk jumped down and helped them get out the door, but it just never occurred to me that it would be a barrier to someone. So we try to think of everything, but often we're kind of learning as we go. So I think it's a great mindset to bring, to constantly be thinking, how could I make this environment easier for people? So
I love that story. And what is great is that there was an accommodation made by the court, but I am going to assume, because I am a judge too, and like I said earlier, that there was a lot, the person was there for not a reason that necessarily made them happy. And what a rough thing to not be able to walk out on your own, right? Like, how would that feel when you're feeling already maybe pretty stressed and pretty bad? And how easy would it have been for the designers to add those buttons? It seems like when we think about it, like, goodness, that would have not been that hard, right? And now here we are with this circumstance, which I'm sure was impactful to watch too, what I'm imagining is that it robbed that person of their dramatic exit.
well, it was a contested restraining order hearing, so already highly emotional. And I think she was there with a supporter who kind of helped out also, but she sat out in the hallway with her supporter, and you could see that she was really upset and felt completely humiliated. I mean, it was clearly humiliating for her. And it was just like a light bulb going off, that kind of clueless of us not to have anticipated that as an issue, but that's how it goes. But yes, it was clearly humiliating for her in an already emotional and challenging situation.
My disability, again, being hearing loss, is so interesting because I notice it a lot more. There's a variety of things that come into play for it. First of all, people that are hard of hearing, and specifically people that are deaf from birth, are often really animated communicators, and that can be misinterpreted as aggression. I have seen more than one criminal case involving a deaf defendant and resisting arrest where I wonder, Was it? Or was the person actually just trying to communicate? You know, I mean, um, when judges are evaluating somebody who's presenting testimony, you know, we take into account physical things. And so for me, that's something that I consider as part of my equity lens when I'm making decisions, right? Is the way people communicate. And there are cultural things that play there as well from people from other countries and things. It's not just because it's not my way of communicating doesn't necessarily mean it is the wrong way, or you know, what does it mean? We should all be careful. And again, especially with those of you with forward facing jobs, um, you know, you're often dealing with people that are in a rough situation, that are not yet pulled themselves together. Often by the time they come and see us, they've pulled themselves together a little bit. And so you all might be dealing with them in the first moment when they've just gotten something and they're coming in upset and they're not their best selves. And then when you add to that a layer of communication differences or comprehension difficulties, then you're looking at a very stressed, angry person. It's easy to misinterpret it. And I don't want to put too much more on all of your plates because, again, you all are doing a lot. But thinking about that and taking that extra moment, it's the same as when people say, give someone grace or something like that, right? Don't assume you know why something is happening, because we don't. We don't know if it's just they had a bad day. We don't know if they're a jerk or if they actually had tremendous difficulty reading that divorce petition they're waving at you in anger. Maybe they don't understand it at all. And all they get is that they're being taken to court. So scary. So that kind of concludes my like organized part. I'm happy for us to like chat if you want questions or even ideas, because this is a constantly learning space for me too.
I'm curious. I recall once, sorry, I should have put.
No, go ahead.
That's what I'm saying. I recall once when I was an attorney and my client, I was asking for some accommodations for some panic attacks that were happening. And the judge expressed concerns that allowing her to have what I thought were relatively minor accommodations would basically interrupt the decorum of the court, you know, and that things like laying down during trials and things like that will somehow, you know, make it that we're not being the highfalutin, fantastic court that we're supposed to be. And I was just curious kind of what your thoughts are about that, because we do have so much ceremony and pomp and all of that that goes into court. And I was just curious how you feel about how those go together.
I love that question. And I have to say, I think that courts can just chill out a little bit. It is very serious what we are doing, of course. But our courtrooms are spaces for the people, not for ceremony. And so I understand there are some more old fashioned than me, judges that would disagree and say that laying down during a trial is unacceptable because it's not taking things seriously. I would argue that that judge is not taking that disability seriously. And that is a much greater problem to me than somebody wearing a tank top or somebody needing a support person. So I am perhaps not the most serious judge. I am not the most standing on ceremony person. I have a couple of old-fashioned hangups. I hate hats in the courtroom. We all got something. Today I had a gentleman appear before me wearing a shirt that said, "You hold the wheel while I hold the bottle," and he was there for a diversion violation. He did not speak English. And so I said to him, "I don't know if you understand your shirt, but it is a very poor choice of clothing for this hearing. Consider that in the future." But really, I mean, what we need to do as judges is control the courtroom, right? That is something we do need to do, because if things went wild, they go wild and justice doesn't occur. But I don't think that I don't have control of the courtroom just because I let somebody have a person sit next to them. You know, and again, there are circumstances. Sometimes you have to think about this more closely. A person who might be doing it to intimidate the other person or something like that. It's rare. People don't fake disabilities to gain something. It's first of all, there's shame around it. People don't do that. It's like this idea of we have to be afraid of someone, you know, and there are other communities that are treated with the same sense of suspicion, like the trans community. And I just don't ascribe to this idea that somebody would go to the effort of faking a disability to gain an advantage. It's just far too difficult to do. So it's a harder life. I guess that's my answer is I would encourage judges to be more open-minded about it and recognize their own skill at controlling the courtroom without leaning on these old-fashioned ideas that everybody has to be a particular way, which is a very, I would call it what it is. A lot of those expectations are also white supremacy at work, frankly. A lot of those expectations are don't recognize other cultures. They don't recognize what it's like to be a queer person. They don't recognize disability. So every time we move towards accessibility or equity, we are helping everyone every time. Any other thoughts or questions?
Did Judge Holmes say have a hand up? You're on mute.
Two things, a comment and then a question. So I really appreciate what you were saying just now about being more, I guess, expansive in our thinking about how we might, quote unquote, control the courtroom. And because it certainly is true that people can become quite escalated in our courtrooms and have other challenges listening to others and things. And it is tempting for us to want to, I think probably because of our own desire for control and order, to kind of try to bring the hammer down as the go-to strategy for that. And so I'd love to see you organize and do a training on courtroom management in a way that's more humane and probably more effective than, the pounding the gavel and I'm the judge and you must respect me approach, which I think tends to just alienate people further and doesn't really accomplish the goal we have of having an orderly proceeding that people can participate in meaningfully. But anyway, my actual comment was about sometimes the conflict, I guess, between a more expansive view of disability and the law. And I was thinking specifically about restraining order petitions and cases where if people file under the statutory scheme for restraining orders for elderly and disabled people, a prerequisite for qualifying is that they be a disabled person. And in your discussion of what qualifies as a disability earlier on, I was thinking about my own vision, which I'm really basically blind without my contacts. Definitely one of those people who I have to feel around on my side table for my glasses in the morning. But because I have contacts, that would not impact the activities of daily living, and so probably wouldn't qualify as a disability for purposes of a restraining order. But given your depth of knowledge in this area, do you find the law and what you think about disability coming into conflict in ways and in situations like that?
I'm reading disability coming into conflict in the situations related to how to interpret it for purposes of restraining orders, you mean?
Right, because you were saying, for example, having a substance use disorder is a diagnosed disability. Most of us probably, until this conversation, would not have found that to be a qualifying diagnosis entitling a person to an elder or disabled person's restraining order. So my question is really about, do you see sometimes the law and your understanding of what disability is coming into conflict in ways that makes your job difficult?
So I encourage a broad interpretation of it when we're talking about accessibility, which is what the ADA is wanting us to do. When we're looking at something like a restraining order, I think a judge can fairly inquire pretty thoroughly, but still, I think that's a fair I'm trying to remember what the law is because I haven't done restraining orders in a long time now. The definition of disability, I think, is substantially similar for those kinds of restraining orders. But I don't think, especially when we're talking about something like substance use disorder, they would be out of bounds to confirm that there is a qualifying diagnosis. When we talk about a lot of these things specifically related to mental health, one of the unfair things that has happened is that we throw terms around so casually, right? Depression, anxiety, those are actual diagnoses, and that is the disability, not the fact that somebody may be sad sometimes and then uses terms like depression to describe it. I have a friend with substantial generalized anxiety disorder, and she has drilled into me this idea that I should be more cautious around the use of the word anxious, because it is meaningful to her. What it means is very prohibitive on her quality of life. What I'm talking about is nervousness. I get nervous before I do talks. It is different. It's not anxious, it's nervous. And so I'm trying to be more thoughtful in my personal life and use of language. And I think that is very reflective, something that's reflective in my decision making as a judge around things like this. I never had an experience with somebody who's substance use disorder as a qualifying diagnosis for purposes of that type of restraining order. But if they did, I would want to know some stuff. When you talk to somebody where alcoholism is a component of their life and they're in recovery, there are questions you can ask them, and if they can't answer, you kind of wonder, Judge Silver, who used to be a judge in Multnomah County, I did a speech with him once, and he talked to me about this stuff, and I've used it ever since. Things like, what is your date of sobriety? If they can't tell you the specific date, they might not be sober because they mark that date. It is important. And I've used that in a few restraining order and child custody cases for sure. And when they get a little shifty about it, then you wonder, well, when the other person says that you're still drinking, I have to wonder as well, just one thing to consider. But I ask them, have they been diagnosed? When? What kind of doctor did you see? Do you engage in some kind of treatment for whatever this is? I think that you can suss out these issues about whether they are truly a qualifying disability for purposes of making that kind of determination. And I wouldn't necessarily go so hard at it when I'm trying to make a decision around accessibility. Because again, to me, there's often not much of a harm in making that accommodation, whereas there can be harm in the environment of a restraining order, making a judicial decision.
Thanks. That's a
That's a great
thoughtful and
question.
helpful answer.
I think that we are running
Close to running out of time. Does anyone else have any other burning questions before we finish? This has been absolutely fantastic, Judge Summer. I will say the main thing after I heard the last talk from Judge Summer, the main thing that I had asked was how to put closed captioning in the courtroom, because I was broadcasting it into a courtroom of Judge Summer speaking, and he talked about how great they are. And I realized that through the Crestron, you cannot get the WebEx to do closed captioning on the big screen. And I was so frustrated. And I know it's something that IT is actively looking at whether or not we can do that, but it's the type of thing that I just don't even think about until someone brings it up. And so having it brought to our attention is so helpful, and I really appreciate it, Judge Summer. Thank you so much.
Thank you so much for the invitation.
So just a quick reminder to everyone to please fill out the survey. Roger has dropped it into the chat, so please be sure to fill that out. And then remember that tomorrow is the first discussion for our 21-day disability awareness challenge. That will be tomorrow, July 7, 12 o'clock in the jury overflow room with Judge Odin Orr. Thank you all so much.
Pleasure to see everyone.